Guests at Inner Temple and to our audience on Zoom, and welcome to the second of two sessions that the Inner Temple International Committee have organised on advocacy before international courts and tribunals. Today we continue with the International Court of Justice and are delighted to welcome a highly distinguished panel of practitioners from both the common law and civil law traditions. And to all of our delight, Master Rosalyn Higgins, Master of the Bench of the Inner Temple and former President of the Court. The session will be moderated by Sam Wordsworth QC. Sam practices from Essex Court Chambers and specialises in public international law. He's regularly instructed by governments in international cases and has appeared in numerous cases at the ICJ. He's a visiting professor teaching investment arbitration at King's College London. He appeared in Guatemala's dispute with Belize, Iran, USA cases concerning alleged violations of the Treaty of Amity, the Ukraine-Russia case concerning Crimea, from which he resigned in February 2022, the Chagos advisory opinion for the UK, Bolivia, Chile for Chile, Chile, Bolivia for Chile, and the Peru v. Chile and Costa Rica and Nicaragua maritime boundary cases for Chile and for Costa Rica, the cases concerning certain activities in the road for Costa Rica, the advisory opinion concerning Kosovo for the UK, and the Diallo case for Guinea. After Sam's introduction, we'll hear from Amy Sander, who also practices from Essex Court. Amy's stellar career has seen her instructed and appear before the court in multiple cases too, including for Belize in the Guatemala territorial, insular and maritime claim, Bolivia in the obligation to negotiate access to the Pacific Ocean case against Chile, Russia in the Russia-Georgia case, from which Amy also resigned from acting in February this year, Japan in the Australia-Japan whaling case, and Cyprus in the advisory opinion concerning whether the declaration of independence by Kosovo was in accordance with international law, and Kenya in the maritime delimitation case against Somalia. Amy is the co-author of the 4th edition of the Law of the Sea, and she's recently published a paper in AJIL Unbound on professional conduct before the court. Amy will focus on ICJ advocacy from the perspective of a common law advocate, and then we'll hear from Maître Alina Miron. Alina is a professor of international law at the University of Angers. She's acted as counsel and advocate in interstate litigation, including before the court. She acted, and there's some overlap here, as counsel for Guatemala in Guatemala's case against Belize, for Thailand in the Chagos advisory opinion proceedings, as well as in the Prayer proceedings against Cambodia, for Nicaragua in the Costa Rica-Nicaragua case, and in the Nicaragua-Colombia case, for Greece in the case of the application of the interim accord of September 1995, Fyrom and Greece, and for Russia in Georgia and Russia. And Amy will focus on advocacy at the ICJ from the perspective of a civil law practitioner. So I'm sure we can all agree that we have a stellar lineup, whether you're participating remotely or in person. And we're very grateful to all of you who have come to join us in person, given all of the problems we've had today getting here. So the sooner you hear from our panelists, the better, and I'll hand it over to Sam.
Well, thank you very much indeed. I'll be extremely brief at this stage. You do indeed have a quite exceptional panel. I think everyone's been introduced very adequately. So just to underline the fact that I think we're particularly lucky not just to have Amy and Alina, who are very well-established practitioners in front of the ICJ with wonderful track records, but also Judge Higgins, of course, former president of the International Court of Justice, and also the author of very important works in public international law, including most notably themes and theories. Advocacy in front of the International Court of Justice presents some very special and particular challenges. In terms of written advocacy, to a degree, in terms of oral advocacy, very much so. So I think I hand over to Amy.
Thank you, Sam, and good evening to you all. I really am delighted to be part of this panel, and just to echo what Josh said about thanking those who've been able to attend in person, given the crazy travel disruptions we've all experienced today. So, as Josh says, I've been asked to speak on ICJ advocacy from the perspective of an advocate from the common law jurisdiction, i.e. a barrister qualified at the Bar of England and Wales. So when asked to speak on this topic, the image of a Venn diagram sprang to mind. Not because of any inclination towards the mathematical, not every lawyer's strong suit, but rather because of the distinct points of both commonality and distinction as regards advocacy before the domestic courts and ICJ. So as to points of commonality, I think of various P's. Persuasion. Your job as an advocate before any forum is to persuade. Pick your points. Part of your role to persuade, whatever forum you're in, key to that role is distilling what are the important issues and presenting your clients their best points. And to persuade, you need trust. Trust between you, the advocate, and the decision makers before you. What Daniel Bethlehem described as the invaluable currency of counsel's credibility cannot be overstated in my mind. And this means not taking bad points or low blows. Stick to the good points that matter. And indeed, the ICJ rules expressly state that oral statements shall be succinct and directed to the issues that still divide the parties. Sticking with my P's, preparation, preparation, preparation. There is just an inevitable hard grind to advocacy, whatever forum you're in, mastering the documents, getting on top of the facts, and of course, grappling with the legal issues. Penmanship. And perhaps here I'm starting to stretch the ease of finding words beginning with P, but my point is that whatever forum you're in, domestic and international, the phase of written advocacy has become increasingly important. Before the ICJ, this comprises of at least one written round, and in my experience, normally two written rounds of pleadings, the memorial, counter-memorial, reply and rejoinder, often hefty documents. I'm part of a team where we've just lodged a pleading that counts over 200 pages long with various volumes of annexes. And I pause here to note two trends before the ICJ. First, the trend over the decades before the ICJ reducing the time devoted to oral hearings. Back in 1969, at the second phase of the Barcelona traction case, the court devoted over 60 half days to the merits hearing, whilst the recent report of 2020 of the ILA Committee on Procedure of International Courts and Tribunals recorded that the duration of oral hearings has been a mean average of 12 hours in preliminary objections and jurisdiction cases and 26 hours in merits case. The hearing a couple of months ago between Chile and Bolivia, in which some appeared, comprised 9 half days. The second trend, and flowing from the fact of these constrained oral hearings, is the trend before the ICJ to increasingly lengthy written submissions. Responding to that trend, in addition to Article 49 of the court statute, which states that second round pleadings shall not merely repeat the parties' contentions, but be directed to bringing out the issues that still divide them, we now also have Practice Direction 3, which expressly provides the parties are strongly urged to keep the written pleadings as concise as possible in a manner compatible with the full presentation of their positions, and stating that the number of pages of annexes attached by a party to its written pleadings shall not exceed 750 in total, unless, to paraphrase, the court decides otherwise. This call for conciseness appears not to have been always heeded in practice to date, but certainly it's important and it's understood that it would be welcomed by the court. The ILA committee to which I referred earlier suggests more needs to be done, and that a fixing of word limits on a case-by-case basis could be agreed by way of case management. Whilst I personally have hesitations regarding the idea of word limits, certainly the dangers of information overload in decision-making and deliberations is not to be lightly glossed over. Toby Landau wrote an article on this topic in 2019. His comments were geared towards arbitral tribunals, but some of his observations regarding the reality of what an individual judge can digest in a certain period of time and the risks of certain heuristics coming into play if there is information overload are really interesting. So, leaving my peas to one side, where I've been focusing on how the advocate from a common law jurisdiction, the UK bar, applies a similar OAMO before the ICJ, I now turn to the differences, and there are significant differences. Today, I'll mention three. First, and to my mind, this is a biggie, regards applicable codes of conduct for counsel. Individuals appearing before the ICJ on behalf of states are not subject under international law to any compulsory code of conduct to help them navigate through issues of professional ethics. Article 42 of the statute merely provides that parties may have the assistance of counsel or advocates before the court. In practice, legal teams before the court are comprised of individuals from different legal backgrounds, either qualified legal practitioners or academics. So barristers like myself, we have a professional code of conduct applicable in our home jurisdiction. But the professional obligations applicable to practitioners from different jurisdictions can vary, and some may not consider that that domestic code of conduct applies before the international court. Those who are academics, or perhaps not admitted to any jurisdiction, may not be subject to any conduct rules when appearing as counsel. And this absence of a common set of professional obligations means that the obligations bearing upon the conduct of particular counsel are unclear. Some attempts to articulate guidelines governing the conduct of counsel before international fora have been made, for example, the International Law Association's Hague Principles, but they're at quite a high level of generality and don't appear to have been referred to commonly in practice. So one practical example of how this plays out in practice, one which I explored in the article I co-authored with Kate Parlett, is that of disclosure. The focus of annexing helpful documents to written pleadings before the ICJ is driven by the fact that there's a burden of proof to discharge, and the court statute says that the written pleadings must include all papers and documents in support. But what about the documents that are unhelpful to your case? There's no clear positive duty of disclosure binding parties to a case, and the court rarely uses its power under the rules to call upon a party to produce evidence that it considers necessary. So here, the absence of a uniform code governing counsel comes to the fore. There are techniques one can deploy to address this. For example, crafting a pleading so that if the other side fails to respond by disclosing a document or series of documents, the court may draw an inference against the non-producing party. But the reality, as I've experienced, is that against a backdrop of an increase in fact and evidence-heavy disputes before the court, both within and between legal teams, different approaches to what documents are placed before the court may be taken. That's the first difference. The second difference I was going to cover is the composition of the bench. Advocates before the English court will be appearing before 1, 2, 3 judges. Before the Supreme Court, there are obviously more, but judges in the UK are from certain legal backgrounds, and you're likely to have access to judgments that they've specifically authored. When in the ICJ, however, it's comprised of at least 15 judges with quite different legal backgrounds and experiences. Judge, the current President Donoghue, last October speaking before the 6th Committee of the General Assembly, referred to judges absorbing ideas of their various domestic legal traditions, quote, like our mother tongues. Further, the court's judgments are issued by the majority, leaving scope to see individual ways of thinking more limited. There may be separate and dissenting opinions or publications made elsewhere. Also, unlike before the English court, the domestic court, where the advocate is normally given an indication of what the judge has or has not read, in the ICJ, you don't get that kind of bespoke indication, and it seems approaches to pre-reading may vary. So a challenge, therefore, is to consider how best to persuade the variety of personalities before you. The late James Crawford wrote, "To take perhaps a trivial example, anecdotes or maxims that may be effective and understood in one literary, linguistic or legal tradition may leave those in other traditions completely cold, indeed uncomprehending. The effective advocate will seek to appeal to some intelligent common denominator of the judges without assuming knowledge which is culturally specific. Ultimately," he observed, "the aim of the international advocate must be to gather the relevant material in a comprehensible, succinct way for the understanding of judges who do not necessarily share either the presuppositions or the advocate's intimate knowledge of the dossier." Another aspect regarding composition of the ICJ bench worth noting is the fact that there may be an ad hoc judge appointed. Pursuant to the court statute, if the court includes a judge of the nationality of one of the parties, the other party may choose to appoint a judge ad hoc in that specific case. Remote hearings following the recent pandemic brought to the fore the particular issue of whether fairness demands that those two respective judges should participate in the same way, both remote or both in person. One can take note of how ITLOS, International Tribunal of the Law of the Sea, rejected such a concern in the preliminary objections phase in the proceedings between Mauritius and Maldives relatively recently. And my understanding is that no such concerns to date have been raised before the ICJ. Perhaps, given the court's recent press release announcing a general return to in-person working methods, it will not be an issue moving forward. I now turn to my third and final difference, and that is the issue of dialogue with the bench. The barrister in a domestic court is well versed in the pitter-patter of questions from the judge, listening carefully and engaging meaningfully. Whilst it can lead to some rather intense moments on one's feet, it does allow the judge, the bench, to cut through to the issues it's troubled by or interested in. And thus it provides an opportunity for the advocate to tailor, to modify, to develop his or her submissions accordingly. Before the ICJ, questions from the bench during all proceedings are the exception rather than the rule. Article 61 provides that the court may, during the hearing, put questions to the agents, counsel and advocates and may ask them for explanations. In practice, the court will not interrupt advocates to ask questions, but may put forward questions to the parties during the course of the hearings to be addressed at some point in the course of the oral proceedings as the party elects, as was done in the Somalia-Kenya hearing last year. And one can readily understand why this is the practice, given the often complex political matrix of the proceedings, the fact that the advocate's replies could constitute part of that state's practice, and the process involved for obtaining instructions in an interstate matter of high importance. There's also the practical difficulty of permitting spontaneous interventions when one has at least 15 judges and they're working in 2 different languages. There does seem to be an increasing appetite at the court to use Article 61 to indicate the issues to ask questions during the course of hearings, and I certainly very much welcome that trend. As now President Donoghue stated back in 2014, we have started more recently to ask questions, and I find that very useful. I imagine that it's helpful to the states as well, because they feel that they have a chance to answer questions that are bothering a judge, and that we just don't just go away and feel unhappy that we never got an answer. Of course, as an advocate, you can try in any event to consider in advance what questions the court might have and address them, although unasked. But whilst the fact you as an advocate before the ICJ are highly unlikely to be interrupted with a question from the bench, the advocacy rule of prepare and expect the unexpected still applies. When I had started making an oral submission to the court, I saw someone walking behind the bench, talking to the president, and the president leaning forward. Miss Sander echoed from the bench's microphone. The horror. Had I said something so objectionable that the president had been forced in an unprecedented moment to interject me there and then? No, the interpreter's headset was not working, and we had to pause proceedings whilst the glitch was fixed. So it turns out that coping with unexpected glitches and heart-racing moments are the advocate's lot wherever we are. Thank you very much for listening, and I turn now to Alina, who's going to pick up.
Thank you very much, Amy. I would first like to thank Josh for this invitation. It's really an honor to be here with this incredible bench colleagues with whom I'm working, but sometimes we are on the other side, including in Guatemala, Belize, as you pointed out. You said that I would bring the view of a civil lawyer. Well, maybe I should have told you that I never set foot in a tribunal in France. So I could bring the perspective of a civil law professor, and I'm certainly bringing the perspective of a professor because before the ICJ, what you have professional lawyers, in particular from the common law countries, less actually from the civil law countries. From the civil law countries, what we have mostly are indeed professors. And I think this really brings another experience to litigation before the ICJ. Maybe another experience, but actually in history, first of all, there were professors that were used to plead before the ICJ much more than lawyers. And I think this is due to the role of the ICJ, and it is quite directly connected to the topic I want to talk with you about. Maybe I should put my time so I don't speak for 2 hours and a half. The role of the ICJ, in the relations between the countries, the role of the ICJ as a participant to the settlement of the disputes, because the professors used actually to accompany states long before they arrived before the ICJ, and sometimes they used to be counsel for those states, even if there was actually no litigation in view or no litigation that would finally arrive at the ICJ. So it's less the role of a lawyer than the role of a litigator, and this is really due to the role of the ICJ as a means of dispute settlement between the states. And this still remains the first, the most important role of the ICJ, to participate to the dispute settlement. And this is going to be my first point. What do we expect as a lawyer and professor lawyer from litigation before the ICJ? The participation of the ICJ to dispute settlement. My second point is going to turn around the particular relation that a lawyer, counsel for state, is having with its client, a sovereign state, because this is really quite different from what we may have before domestic courts, when normally you do not deal with the sovereignty of the state that is not at stake before the tribunal. And if I have the time, on my third point would turn around some particular techniques, in particular concerning evidence before the ICJ. Amy touched upon a little bit, and I'm going to add some points from my experience. So first of all, the participation of the lawyer to the dispute settlement, in particular when this dispute settlement is brought before the ICJ. Well, if you take it from that point of view, litigation, it's not an end in itself, and it should not be considered as an end in itself. It is a means towards something, and we should not forget that that something is to have the two states settle the dispute and resuming, if they interrupted, resuming their normal relations. And from that point of view, litigation remains combined with amicable settlement. And as a lawyer, we always have to keep that in mind, that litigation is not a means in itself, but participates to the dispute settlement. And how can it, the best way to show this is that litigation mostly combines actually with the first means of amicable settlement, which are negotiations. Litigation combines upstream. So as I said, the lawyer can actually be a counsel before it is a lawyer. It is a counsel who is accompanying the state throughout the negotiations, and always from the shadows. It is rare, if almost never it happens, that the counsel, especially the external counsel, would participate to the negotiations. But there are intensive exchanges between the state and the counsel, the professor or the lawyer, upstream litigation. And this is going to be quite important, because the worst thing that can happen to a state is to be surprised by litigation. There is a poker game to some extent when litigation is brought by the other party. And if one of the states has not considered the possibility to be triggered before the ICJ, well, all the positions that that party, that state has taken during negotiations may turn out to be quite difficult to defend in litigation. It happened to me several times that we have to defend some positions taken during negotiations, which did not really were compatible with the jurisprudence of the ICJ on one particular point. So if that state does not foresee the possibility of litigation without actually needing to go there, well, first of all, it's going to be difficult to defend the position that was taken during negotiations. It does not mean that the positions taken during negotiations are binding upon the state. Well, if there was no settlement, there is no obligation. But still, as a lawyer, you know that when you have to defend something, well, if you don't really consider it to be compatible with the general trend of the case law, you know you're going to have a hard case. And if you have to retreat from the positions taken in negotiations, that's also a difficult case both for the state and for the lawyer. And this is this brings me to another point. When you are going to litigation, well, when do you decide to go to litigation? When you consider as a state and as a council, would you recommend to the state to go to litigation before the ICJ? This really, of course, this is a decision which is taken by the state. It's up to the state to decide if the compromise is impossible. It's up for the state to decide if it would have a better decision from the ICJ than a decision which would be reached by agreement, a compromise which would be reached by agreement. This is really up to the state to decide. At the same time, it is the role of counsel to inform the state of what might be expected from a decision. And I think a state can only take a reasonable decision, a lucid decision, having in mind what it can get from litigation. Now, as a lawyer, of course, your role is also to inform the state if litigation before the ICJ, but not only, is actually possible. And this brings me to the issue of consent. I suppose most of you have had some classes of international law, but still you know that in order to be able for a state to go to the ICJ, it must prove the existence of consent of both parties to litigation. And therefore, as a lawyer, well, if you want to play the game of litigation, you must be sure that you have a basis for jurisdiction, meaning you must be able to prove that you have the consent of the other party. There are some procedural conditions also, which may be included in the basis of jurisdiction. And as a lawyer, you you really must know that those conditions are or not fulfilled. This is not really difficult, but in some situations, like for instance, the United Nations Convention on the Law of the Sea, the conditions are quite ample, and you must actually make a thorough examination of the possibilities to get jurisdiction or not. Of course, if there is no basis for jurisdiction, you may hope that one day the other party will agree to go together. And actually, this is the royal way, the avenue for the ICJ, because when you have an ad hoc agreement on the side of the other party, of course, the chances of having the decision implemented are also much higher. So these are the ideal conditions under which a states will actually go before the ICJ. Again, on the combination between litigation and amicable dispute settlement. It's because the purpose of litigation is to have the two states actually settle their dispute. The role of the lawyer is also very important during the proceedings if one day we get to litigation. And the guerrilla tactics that you may see in some movies do not actually work before. Not only they are counterproductive before the ICJ, because courtesy is most appreciated, but you must also keep in mind that the relations between the parties during the proceedings should not be relations between enemies, not the least because it is possible during the proceedings, but actually the states will continue negotiations and sometimes they will reach an agreement during. This is not actually, is not a, how should I put it, a failure of litigation. On the contrary, if during the proceeding states reach an agreement, this is a very nice settlement. But we've seen some cases, without giving names, I understand, where some counsel actually took the position that the best way to defend a client's interest was to advise for the guerrilla tactics. And the guerrilla tactics may go as far as actually counseling the state not to appear before the ICJ. Okay, it's the sovereign right of a state not to appear before the ICJ, and normally no negative consequences will flow from this. Still, a state which does not appear will not present its position. It loses the possibility to present its position. And another way of not really complying with the courtesy rule before the ICJ is actually recommending a state not to implement the decision. I think this is the worst a lawyer can do. If a decision is adversarial to the expectation of a state, to recommend the non-implementation of a decision, I think it's really a bad counsel. I'm really wondering myself if this is compatible with the role of counsel in international law, because actually lawyers are passing, but states and their relations remain, and it is important in the end to allow for the states to resume their relations. Now I'm getting to the second point, which is the relation with a client, which is a sovereign state. Well, there are many peculiar points from this point of view, but there are some issues with which a lawyer does not have to deal in domestic courts in general. First of all, you must be particularly sensitive to the domestic political reality and equilibrium. Sometimes you cannot plead what you would like to plead because this would be politically unacceptable. The lawyer before the ICJ, the lawyer for a state which is a sovereign state, is not the master of the case. Really, there are important political issues to be taken into account, and your way of pleading the case must reflect the political decisions. That's one point. The second point is, before the ICJ, we have an agent, and the agent is the one representing the state, and the lawyer is under the authority of the agent. From this point of view, again, this is an important difference with the domestic courts. Third difference is actually that the speeches, because we are representing sovereign states, and because what we say is actually the position of the state before the ICJ, well, the speeches are controlled from the beginning until the end. They are controlled not only by the other counsel, and this is quite important to have a good speech, to have the control from the other counsel, but also controlled by the political authorities. That's why when you look at the pleadings at the ICJ, it may not be completely exciting, but there are, these are written and spoken, well, read speeches, but because we need to have this control of over what it is said. And again, on this relation with the client, which is a sovereign state, I will like to raise some issues concerning deontology and the ethics of the lawyers you touched upon. And as Amy said, we do not have a common code of conduct. And I think this is a problem because indeed the lawyers, barristers have a code of conduct from their domestic from the domestic jurisdiction, whereas professors, well, they do not have, well, they have the code of conduct as professors, but of course this is not applicable before the ICJ. And there are some issues like, for instance, what do you do if you have a state which is bringing you evidence which is was not obtained by legal means? Yeah, what do you do with that? Do you say, well, this evidence is great, we'll bring it into the case because it serves our purpose? Or would you say, no, we cannot bring this evidence before the court? So these are the kind of issues where a code of conduct will be quite helpful. What about retaining evidence? Of course, we choose the evidence we want to submit, but because it is persuasive and because it is relevant, but retaining evidence is not putting evidence which is persuasive and relevant. Well, persuasive contrary to your interest. And this issue was actually raised before the ICJ. In the first case, it had to deal with the Corfu Channel case. And we have some interesting testimonies about not submitting evidence in that case. And the third point concerns something that has happened quite recently, the public statements of a lawyer who is resigning. This again, I think, raises some issues because there is nothing which is forbidden in a non-existing code of conduct, but I think in domestic code of conducts, this would raise at least some issues. So this is the end, in a very opportune way. So I will not be able to touch upon the technical points concerning evidence, but I'm open to it during our discussions. Thank you very much.
Judge Higgins, please.
Thank you. Well, I've much enjoyed listening to the two presentations. The role of the advocate, whether from a common law or civil law background, is from the perspective of the bench to assist the court in finding, some might say, the right solution, some might say the most inclusive solution. That depends upon a whole range of other issues, which is not our topic for tonight, but it's to assist the court, obviously to do your best for the client. But I think I am right in saying, the two of you may take me up on this concept of the role being to assist the court is very particularly embedded in the common lawyer. Now, one is often asked by new counsel, how do I go about it? Do I just address the president? Do I swing around along the long line of bench, which can be even longer when there are ad hoc judges? And I always have taken the view that making eye contact with the entirety of the bench, which requires a certain amount of gentle head movement, is the way to go. It has its dangers. When I was acting for who was I acting for? Against Australia. I was busy telling the court how iniquitous Australia's behaviour had been and how one wouldn't expect it of a country like that. And eventually my eye contact got to the Australian ad hoc judge, who gave me the most enormous wink. And it totally took the wind out of my sails. So you, as you say, you have to be prepared for anything, even, it seems, even that. We've seen over the years the composition of the international bar, which, as our two speakers have said, there's no formal bar, but there is a sense of belonging to an international bar, even if there's not a common code of conduct, and the composition of those appearing before the court on a regular basis, I think has through the years changed. When I arrived at the court in '95, it was one invariably had in front of one French counsel, British counsel, sometimes Spanish and Italian, but rarely many else. These days, not only does the bench have the ability to benefit from female counsel, but also counsel from the countries bringing the cases. Over the years, they've built up their own cadre of very capable legal advisors, and they can make a very effective contribution. Often that is mixed with having leading well-known counsel who appear for a variety of countries, and counsel who are the counsel in the employment in the foreign offices or equivalent of the country concerned. And I think we've seen this especially in Africa. It is extremely important that the counsel know their law. Of course, there's the principle that the court is assumed to know the law, but nonetheless, the court will benefit from assistance or from particular glosses that are put on complicated points. We had in a range of Central African cases, and I will name the counsel, Maître Verger of France, who was well known as counsel for the underworld and was no doubt extremely effective in that genre, but an expert on the court he was not. And the court sat afterwards and regarded some of his submissions with surprise. So you need a counsel who knows a great deal. And as has been said, because the court is essentially based on consent, the jurisdiction, but there are many ways in which that consent can be given in advance or trammeled. They also need to know the law, not only as it applies to the particular case, but as to issues on jurisdiction and admissibility. And admissibility incident is a very complex question because it appears at later stages in the case than one might expect. It's important, not least because the court is deeply divided on a common law, civil law basis. It's important, that's a specific remark, not a general remark. It is important that there is not extended repetition in the oral phase. I mean, this is the only court in the world that has full written pleadings and full oral pleadings for all the political reasons when drawing up the statute that you might imagine. But going back to my specific point, the civil law judges see no need at all for any oral pleadings. They largely think it's a waste of their time, and they're happy to have the written extended a little bit, but on n'a pas besoin de l'autre. And so one certainly should be very careful that counsel does not repeat what is in the written pleadings. Of course, you may say, and as we have spelled out in this pleading or that pleading, and then develop it from there. But there was one very well-known, very capable counsel who simply repeated his very well done written pleadings, and it got to the stage of being a small joke among the court that no doubt they'll get these pages from the pleadings, and it was so, and counsel got to the stage on the other side of actually drawing the court's attention, leap to their feet à l'impelé and say, what you're hearing now, you can find in the memoir at page this, paragraphs that, if you want to follow it there. And this had no effect at all upon the counsel who was doing the repeating, who just ploughed ahead. It did not shame that counsel, but it doesn't go well down with the court. And it also is very much a tilt towards the civil law judges. I put it that way because at the end of the day, we're all international law judges, but as Amy said, we all come from different backgrounds, and the attributes of those have undoubtedly run off. Now, on this question of questioning, really everything has been appropriately said here. I know common law counsel do find it a disappointment that they're not subjected to the rigorous questioning that they would get in an English court, for example. There's the terror of it on the one hand, but the feeling it's part of your legal practice on the other. I think the court is doing and has done what it can do about it. It would not be, I think, conceivable to have 15 judges, and the ad hocs have to be treated the same way, so it could be 17 or yet more, jumping up with questions. Imagine if you had 15 Michael Mustells having a go at you. you would never get beyond the first small point that you had to decide. But it has become a little more flexible. There is incidentally the practice, which I believe has not changed since I left the court, the practice that in the customary meeting in the so-called Rose Room, that's where the judges gather together a half hour ahead of the case in the morning to talk about any knotty issues on the horizon, in such a case, I'm going to pause there. I'm just coming out of food poisoning and my mind is not as crystal clear in retaining. I'll come back to it in a moment. Oh yes, now I'm immediately back to it. The custom has always been that it is for the judge who has a question in mind to have it in French and in English for the colleagues, and they can make little suggestions on it. Occasionally it's said, I really don't think you should be asking that at all. And the most usual reason for that being said is that there are some judges who believe they should keep their cards very close to their chest till almost the last minute, and they shouldn't be giving anything away. Of course, most of us have experienced a different way of thinking, that if you have an issue, whether it turns out to be that important for you or not, you need to share with counsel that you need it clarified. But now, as you'll have heard, their questions are allowed at the end of each of the rounds of pleadings. Very occasionally, they can be answered immediately, but because the clients are sovereign states, most usually they're given a relatively short time to come back with the answer. I remember graphically that in the Botswana-Namibia case, which was about, in essence, about the nature of the River Chobe, I asked if I could, in due course, receive some accurate measurements for the depth of the Chobe at a particular point. And to my pleasure, that result came in not long after, and I had the picture of a buffalo standing up to them. So again, you never know what might come. The court does have, it can't be denied, it does have favourite counsel. It doesn't mean by that that they are more likely to go along with the arguments of that counsel. I'm simply talking to you about the judges saying, oh, tomorrow we'll have such and such. That's going to be interesting. And everyone is genuinely looking forward to that. And I would advise counsel, don't try any jokes. They invariably fall flat because what you know and think funny, the judges have no idea what you're talking about. Don't be too chummy. There are a handful of counsel who can get away with that, but only a handful. For example, Eli Lautpacht could get away with it. The court loved hearing him, and Eli told anecdotes that he somehow found relevant to the point he was making. He told anecdotes invariably against himself. So the court rather liked that and enjoyed hearing him. They must have tremendous knowledge of the law, as people like Alain Pellet and other well-known counsel do. They should make full use of the practice, the directions, as well as the case law, as well as, if you can possibly make the time, important bon mot in separate opinions. And it is really important in certain types of cases, particularly those relating to titled territory. Have a good map person on your team. There are some people who can make what they need to tell you about maps, which incidentally, nothing will ever turn on a map, and the court has made this clear many times, but you can get a trend, or you can see that something has changed from one map to another, and why and what happened. So maps have an important part to play. And counsel who are good at taking the court through maps and explaining what legal benefit their team can get for it are much appreciated by the court. So of the recent generation, I'd pull out the name of Rosalyn Bundy, who can make a day of maps. Absolutely fascinating. And then there are those counsel who are almost the opposite of the Ellie Lauterpath style, talking to the court, taking you along with you, who systematically go from A to B to C, but do it in such a professional way that it's hugely appreciated by the court. And in my time, I would think of Arthur Watts as the counsel who fell into that category. The court really appreciated knowing they'd have no flam, no jokes, not boring though, everything explained clearly and how one point links with another, all beautifully laid out. Now, there is, of course, the question that's been referred to on digital evidence. The court has a good many years now accepted all forms of evidence. It is, as Judge Tomka once said when talking to the Sixth Committee, President Tomka as he was then, the court has great flexibility. That's the essence. There are certain rules and constraints, but that has allowed seamlessly to move into the presentation of digital evidence, which had not, for obvious reasons, existed before. This is one of the things, incidentally, that the court will meet about in its pre-meeting in the Rose Room, to say this morning we're being asked to show a video or something of that sort, and the president will say there seems no problem with this, and by no problem it means first that reference was made to it in the pleadings themselves. This is not something new. And secondly, that the other side knows about it. It's not jumped on unexpectedly with this presentation. If a particular piece of evidence, most usually digital, but it doesn't have to be, it could also be written, of written character, comes up not having been in the written annex to the written pleadings, then it is allowed if both parties agree. I would have pushed for a practice direction change on that, but was not successful. And it's also allowed if, even if it was not attached to the written pleadings, it is commonly available. So even if counsel from the other side haven't seen it before, you'll get it at the first library you go to online without any difficulty. When a case is brought to the court by compromise, which Alina mentioned, she interestingly said that a party may think there's a better chance of the judgment being carried out if you both go with the same set of questions you want answers to. I agree there's a very good chance of that, but in fact, the court has an astonishingly good record of judgments and opinions, especially judgments, being carried out, which I think stand up well against most domestic courts. One thing neither of our excellent speakers has mentioned is that cases brought by compromise, where the two parties together have agreed on what questions they want the court to answer. Those types of cases have the ongoing problem still to be resolved, that neither party usually wants to be seen as the plaintiff. You can't have two parties speaking simultaneously to the court. And so there is the issue of what happens about it. And the court has again in practice direction said parties, when drawing up the questions for a case to be brought by compromise, should really decide between them who is going to speak first in usually 2 rounds for each of pleadings. And by all means add to that, this does not mean we're taking the position of applicant. It does not mean we're taking the position of respondent. As a matter of convenience, we have decided a tremendous amount of court time is wasted on cases where this is not decided at the moment of the submission. So at the time the court starts reading the pleadings, it has no idea who is going to be speaking first. So there's a great deal of shadow boxing about nothing very much of interest in the first round and a response to that. So you finish up essentially with 1 round in those cases, and it's been brought upon yourselves. So that is something it would be really good if counsel could lend their weight to. There is the very, very big question of ad hoc judges. They have, of course, to be treated equally, and the court will have to decide in particular times, in COVID times when travel is not possible, whether this really means everything has to be absolutely identical. But the court will do what it can to keep that feeling of equality, and also in the life of the court behind the scenes. The ad hoc judges, every effort is made for the ad hoc judge to feel part of it. Nothing of any importance is decided in their absence. All sorts of things are quite trivial, things are held over so that they don't feel they're not being consulted. when I was president, I asked the General Assembly to think seriously about that composed of states members, of course, to think seriously about not appointing ad hoc judges when neither side had a judge on the bench. One can understand, in spite of the solemn vow you've taken to act not in the national interest, one can understand the feeling that if there is a judge of a certain nationality relevant to the case on the bench, and not another judge whose nationality is also involved in that case, that there's a desire to appoint an ad hoc judge. But when neither of you have it, it really shouldn't happen at all. And I think it was Namibia, Botswana, where they both decided not to. That's to my best knowledge, without having checked that recently. I agree that it would be extremely useful to have a common code for barristers. There's the big issue of evidence that's been alluded to. It's a huge topic, I addressed the 6th committee, and I think I was the first judge to do so on that topic. Since then, Presidents Tomka and Yusuf have followed up with their own thoughts on that. But the civil lawyer is very reluctant to identify for counsel the standard of evidence you would want in particular cases, for example, the genocide cases, which come close to criminal law cases. They're not criminal law, but they're close to it. Is the standard of proof there really the same as in other cases? It can be readily agreed that counsel making a claim has to prove it. That's an easy one. But the standard is quite difficult. This was something, again, I can say now, I used to argue all the while for us to have this, and I think you can see from what I wrote in oil platforms that I found it very difficult not knowing the standards that we were aiming at. We could all agree certain things seem to have happened, but what about the standard? And the civil law judges would say, c'est l'intime conviction. And that was the answer. So if you knew it, you knew it. So these are interesting things, I think. Of course, I think there has grown over the years a common consensus on the bench, and you can see it through a series of cases that you will give greater weight to evidence, purported evidence, that either comes from a rigorous analysis before, perhaps by a judge. You had the Porter Commission in Congo, Uganda. We gave a great deal of weight to that, or by UN bodies, reports from them, though there have been occasions, and I'll leave you to work them out, where the court was clearly not very impressed with those and didn't do so. Well, I think that's probably enough from the perspective of the judge. Thank you.
Well, I mean, thank you so much. That's absolutely fantastic. And we've had 3 really terrific talks. I'm going to open it up for questioning in a moment. I think I'm meant to say a few words in terms of summary or drawing strings together or something like that. But I really don't think there is much to be served by that, other than perhaps to emphasize 2 or 3 points, which have all been touched on already. The first point, sort of picking up on what the panel's been saying about restrictions on questioning. I think that just means it's all the more important to make that mental leap to the other side of the bench, to try and ask yourself, well, what is going to be troubling these judges? What are they really interested in? And that, like Amy's mentioned, you know, that means it's so important to focus down on what are the real issues in the particular case. And once you've identified those issues, which of course the oral argument is going to enable you to do, then how can you best address what the judge's real concerns are going to be? And that really leads to a point that Alina was making about considering what can be achieved by litigation. And there, I think, obviously counsel plays a very important role prior to a case, trying to keep the client fully informed about what it can achieve, and during the case, what can be achieved. And in thinking about the judge, what is the judge, or the 15 of them, what are they likely to be thinking? How are they going to be responding to these submissions? What are the questions they have in mind? How can you address those? How can you get a realistic order for relief that you're seeking? So I think there's an awful lot of thought that has to go into the advocacy. Of course, both written and oral. Amy's point, don't take bad points, is for me critical. Not all counsel agree with that. Some of them will say, you know, it's only pleading.
Yeah.
For me, I just do not understand that.
Do you think this is a civil law, common law distinction?
Well, when I certainly the lawyer who I hear most often say that is from a civil background. And I think it's so important that when you get to the oral phase, particularly, that you distill what really matters. And Amy's point about the invaluable currency of counsel's credibility, I think really counts there. And what you say, for example, about Sir Arthur Watts, or about how the court has favorites, certain favorites, I'm sure part of that is that you know what you're getting has been seriously filtered and is reliable. You may not agree with it, but you know that it's reliable and serious and sensible.
Sometimes it's been said to me, well, we'll make a bad point because then the court can give something to the other side. And I just don't understand that as a coherent legal strategy or of assistance to the court, which is what you referred to as the imperative.
Yeah. Well, I mean, that sort of takes us back to a very interesting question on the judge's approach. And the court, it used to be said of the court that it often is looking for a sort of a median line. But I see that much less in the past 20, 25 years. I think that the court is these days very, very capable of deciding yes, no to cases and coming out with answers which aren't in any way sort of trying to plough some middle line, but are just applying the law as the court is seeing it. I think another point just to emphasize is the point about avoiding repetition. That again seems absolutely critical. And I think that's something we learn in domestic courts, in front of the European Court of Human Rights, or wherever it might be. You know, essentially less is more. And if you have an opportunity to say things fully in writing, that's great in the first round. The judges say, and they really mean it, in the second round of written pleadings, don't repeat it, just be truly responsive. And then the oral pleadings, it's absolutely critical just to get to the points that really matter. That's not always easy, of course, because I think you're dealing with a bench where some judges will have read a lot and others will have read less than a lot. So, and that's something we, you know, maybe we can explore in questions. Anyway, I think that's probably enough from me, and I'll turn it over to questions. Questions from the audience, questions from the virtual audience, or questions that I have on my mind.
Good evening. Hi, I'm a student member within a temple. I'm from BBP London. My question is with regard to the appointment of ad hoc judges. And where earlier you mentioned where it would be preferable if moving forward, when, not to say plaintiffs or respondents, people entering the ICJ would not hire or ask to appoint ad hoc judges where possible, right? However, because where does that line start? Because when you include political interest, let's say we take, for example, with Egypt, and let's say they're having a dispute with any other country other than Sudan. They have clearly a very large core geopolitical dispute with regards to access to Suez, to the Nile River, to water from the Nile River currently. And therefore, if I was representing the Egyptian side, I would ask to appoint an ad hoc judge the moment I see a Sudanese judge available on the panel. So I just wanted to ask whether you could clarify on that. Where does that line actually stand? Thank you.
I think that's the judge.
Well, I don't disagree with the way you've put it. The ad hoc judge can play a useful role, and particularly in assisting the court with relevant domestic acts of legislation with which the court won't be so familiar, and being taken through the sequence and the things that were happening that gave rise to all of that is immensely helpful. So, for example, in the Canada-Spain fisheries case, the ad hoc judge from Canada explained all sorts of things to us that would, quite frankly, have escaped us otherwise. And the ad hoc judge in cases that come close to the criminal are often judges with an international criminal law background, and that can be helpful to us too. But my point was, when both countries are in the identical position of not having anyone, it's for their counsel to put all their arguments and their claims. The counsel don't have special points of information to bring to the court. That's not their major task. It may be an incidental task. So it was quite a modest thing I was unsuccessfully asking for.
I don't know if I can just add a point. I think it's all the more valid that nowadays most of the ad hoc judges are actually the same judges which do not come from the country itself, so they do not bring a particular domestic point to discussion, but are the same persons which are appointed. And I think some states think that the role of the ad hoc judge is to be a counsel on the bench, and I think that's the worst way of envisaging the role of an ad hoc counsel.
I mean, we have had the unusual example in recent years, and there'd only been about one example before, of an ad hoc judge not voting in favor of the country who had appointed. And if I may make a personal remark, on my very last day at the court, there was a truly unanimous decision in which the ad hoc judges all voted together. I think it was a sort of farewell present. But they've apparently both felt very, very comfortable with that, seeing the law the same way. It was between Romania and Ukraine, so I don't think a lot of that case sadly remains now.
A question I think which may be more for, which certainly comes out of something you've said, Alina, and maybe you'd like to answer it at least first, which is why the positions during the negotiations are revealed during litigation, and the nice point that's being made here is, doesn't this deter parties from collaborating if litigation may be on the horizon because they're afraid of what they're being said, of what's being said, being used against them? You're saying, well, of course, it's not in any way binding that state, but supposing you've got let's say a maritime delimitation case, and the parties have been negotiating, as indeed they are obliged to do, and it's clear from that delimitation what the parties have, at least in a sort of broad sense, been willing to accept as being some form of equitable resolution of their dispute. Ultimately, they haven't agreed to that. So are there difficulties?
Well, I think there are 2 points there. The very fact that there is no prohibition on bringing the evidence from negotiations, what were the parties' submission, unless the party decide that it should not be brought. There is a case now ongoing. There was not a question of negotiations, but of mediation. And during the mediation period, before the mediation actually started, the parties decided that whatever will be said during the mediation won't be brought before the ICJ, but otherwise there is no prohibition on bringing that kind of evidence. So the problem with that is that when the parties negotiate, well, they may take, I'm not an expert in negotiations, but they start, most of them, if they are not experienced negotiators, they may have the feeling that they should ask for a lot in order to get something. And this is a position which is quite acceptable in negotiations, but this is not the way you would plead the case before the ICJ, including in maritime delimitation. So if you have to plead the maximalist view, which does not coincide with the case law of the ICJ, as a lawyer, it's quite difficult actually to justify that maximalist view. And for the state, if the position that was put before negotiations was made public during negotiations at some point, retreating from that may be considered in terms of territory or of maritime delimitation, even as a form of treason. So that brings some political problems inside. Now, during negotiations, indeed, parties may seem to reach an agreement, but unless they reached an agreement, it means that they could not to find a compromise that was acceptable to both of them. And I think it's quite difficult to present as an agreement something that was not really formally agreed during negotiations. And I think this should remain. I think the court was quite careful not to endorse small points in negotiations of form of agreements when they are not.
Judge Higgins, Amy, anything to add?
I have nothing to add to that, I agree.
Might it be sometimes the case that a state can see the benefits to reaching a certain agreement during negotiations, but for political reasons might choose to go before the court because there's an element of sell to the domestic audience if a certain position has been decided by the bench, perhaps?
I mean, that must be right, and also a certain element of sell that we really have done what we could. Of course, and this is a slightly different but related point, Judge Oda, who had his very own distinctive way of thinking about international law, he remained convinced that it was a pre-requirement that no case could be brought unless there had been a prior negotiation that could be shown to the court. And that was why, among many reasons, he found it was not cases A, B, C, D, E, F were not within the jurisdiction of the court.
Thank you very much. We've got a slightly provocative question from Professor Eric Bilger, which I've carefully now lost from the screen. Oh, thank you very much. Yes. No, it's gone. But basically the question was, well, what really is the point of this oral phase? Because all that's happening is counsellors showing up, they are reading out a pre-prepared speech. So does the court really benefit from that? We certainly have the judge's eye view here, and indeed other judges have spoken out on this issue, but perhaps Judge Higgins, your thoughts first.
I mean, I do think it's anomalous that we have full-fledged written and full-fledged oral, but that's the way it is for all the reasons we can understand. But I would say that more often than not, the bench does get something from the oral phase. And I can certainly in my mind's eye see certain judges not in principle well disposed to oral pleading say, well, that was interesting and I hadn't focused on the such and such point. And that happens not infrequently. And all the more reason not to be repeating then, to be picking up points that are still hanging in the air and developing those.
Alina, anything to add or to sort of justify your very existence?
Well, we are entitled to some excitement, and I think that is indeed the most exciting part. But beyond that, it's like a professor. I can give a 2,000 pages book to my students or speak for 30 hours during a semester, and I'm really sure they understand better. I'm not teaching the court, it's not what I'm saying, but I think it's something like that. The oral forces us to focus, and I think that's quite important.
Yeah, and I'm just thinking back to experiences during hearings. As the counsel, you're aware of the ground shifting as the oral proceedings progress, and suddenly points that you thought you maybe had in the bag suddenly feel a little bit more shaky, or points that perhaps you hadn't anticipated would be put so well. So I think that feeling reflects the effectiveness of the oral advocacy.
Yes, and at least we have judges going on record to say that their minds have been shifted 180 degrees due to the oral phase of a hearing. So I think they do serve a purpose. As to the point that you've got this written phase, which goes on rather a long time and can be very weighty indeed, and then the full oral phase. It's interesting to note that the court seems to be cutting back more and more on the oral phase. So, for example, the Iran-USA case that's coming up in September of this year, the merits hearing is taking place within 1 week. And that's not the court sitting morning and afternoon on all those days. So I think there is a tendency to be focusing and to expect the advocates to focus more and more during the oral phase. A question from Jack.
Can I just add a little something to that? The court has very recently started to hold Article 1 deliberations, which it had never done before. And during my 15 years there was heavily resisted. They are, there are Article 4 deliberations, which is when after a case is heard and you've written your judge's note, which is really an informal style opinion on it, which then gets translated and you all meet together and discuss it. And it's up to the president to organize how that works topic by topic, or what are the big ones that would mean you don't have to get to certain other points. That's up to the president. But an Article 1 deliberation is a deliberation whereby the court meets very early in the case to try to identify what seem to be the key issues, what some early research from within the court would be helpful on. That was indeed over the years resisted by those judges who like to leave their reading till very late and perhaps benefit from the reading and work done by others who started early. But at James Crawford's memorial, I ran into current President Donoghue, and she told me that was now underway and was proving useful.
I mean, from a council perspective, that sounds very interesting indeed. And it calls to mind the practice of the European Court of Human Rights, where prior to the hearing, they're often saying in clear terms what they want the hearing to focus on. And one wonders if the ICJ will be moving more in that direction.
It is indeed going in that direction, yes.
That sounds like a very, very encouraging development.
Yes.
A question from Jack Walker about I's and T's, indeed, and saying that there are 3 I's: integrity, invisibility, and irresistibility. And there are 3 T's: truth, test, that's evidentiary test, including the test that would have to be applied, which of course is critical, and trust. That's in the context of domestic courts. Does it apply equally before the ICJ? Amy, what would you?
Well, integrity, certainly. invisibility, which he describes as, in other words, being a vehicle for the submission rather than showing off. I certainly think that egos are unhelpful in the courtroom, and that you have the role to assist the court, to persuade the court, and to present your client's best case. Irresistibility, I'm not quite sure what that means, but perhaps he means credibility and taking the good points so that what you're putting forward is an irresistible argument. Truth, I feel like that's a separate seminar. Test we've touched on, and trust, absolutely, that was something I referenced, and I think that is absolutely key to the role of the advocate in whatever forum, and certainly before the ICJ.
I think we're now 5 minutes over time, so perhaps we'd better be wrapping up very shortly. Unfortunately, that means we're not going to be able to address all these questions. It's very nice of George Tasitsky to be saying thank you very much to everyone. I wonder, just because all the panelists have touched on the question of ethics, which is terribly interesting, and obviously the codes that apply to individual or practitioners from different backgrounds are themselves different, or possibly even non-existent. And I wonder if that is anything that ever features in the judges' minds, that they actually distinguish between those who are bound by ethical codes or not, which I guess would be rather difficult, because even though you know what certain ethical codes may say, how do you know that even though somebody is not bound by that ethical code, they consider that they have to act in accordance with that code?
Yes.
So making assumptions might be slightly unfair.
I think the court does not, in a particular case, set it against an ethical code or the absence of one. I think it's much more a question of personalities, and the court will know with counsel they see with a certain frequency. They'll know when there are attempts to lead them by the nose, that they'll know a counsel who says, and in this 2,000 pages, in subsection this and that, you'll find that X and Y, when you turn to it, you don't find that at all, because they assume you're not going to. And that is something the court deeply resents, and it has happened, and that person will never be trusted again.
Well, hats off to the court, and key for trust. Amy, Alina, final words, or no? Well, thank you so much. I have to say, outstanding panel, and I do hope everyone has got a lot from this. So Josh is just going to say a few words.
Well, just to thank you all tremendously on behalf of the International Committee of the Inner Temple, and also to thank Jenny and Wanda for such a superb job organising the logistics of both this session and the session last week. And also I'd like to thank, if he's watching, Hannes Jobstel, who's clerking at the court at the moment for Judge Nolter, who has been a massive help and guide to me in terms of suggesting you and introducing many of the topics which I humbly requested you to consider addressing, which you all have done and which we've all benefited from so greatly. And finally, thank you to our technical team for putting it together, even though we're we're small in number here. I understand that we are a greater number in the cloud, and that's thanks to you guys. So thank you very much indeed. And finally, to the International Committee itself, it's chaired by Master Kieran Beale and Joanna Corner, Her Honour Judge Joanna Corner at the ICC now, who have been tremendously supportive as well to us putting on these events. So thank you finally to you for coming. It's great to see you, and again to our panel, thank you.